Welcome to the chaos sector. We return to the matrix. In the last episode, we left a comment regarding Ann Taylor's approach to the trial. We pointed out that Taylor needs to get a bit tougher because she is being bullied in the courtroom. That's right. The prosecution and the judges that are presiding over these hearings since Koberger's arrest have been basically bullying the defense. You have to keep in mind, the state is collectively fighting for a guilty charge. And based on how these judges have carried themselves, we can suggest they are leaning towards the state. We were only going to focus on the trial after we summarized our investigation. Why didn't we care to focus on the hearings? Well, here's an example of why.
Your Honor, our position is that the court should suppress the IGG identification and everything that flows from that. This is supported by Fourth Amendment of the United States Constitution, due process, Article 1, Section 17 of the Idaho Constitution. Your Honor, there was no warrant for several phases of the search that led to the IGG work, investigative genetic genealogy. And we think every single one of those stages, a warrant was required, none was given, and so this must be suppressed. Your Honor, I'd like to identify the three stages, and they are when Idaho State Police Forensics Lab, through Moscow Police Department, moved a DNA sample off from laboratories to develop a profile to run through genetic genealogy investigations. There was no warrant for that search for a SNP profile that could be used to attempt to identify somebody. The next stage would be when that was transferred to the FBI for their forensic investigative genetic genealogy work to try to identify somebody. No warrant was in place for that work either. Finally, there was a trash pull in Pennsylvania, and there was no warrant for that trash pull either. All three of those stages of this case, there should have been a warrant, and there wasn't, and this must be suppressed.
Okay, now, this is by the law, but what Taylor is apprehensive in confronting is it not only was unlawful, but the intention behind the unlawful activity is the main focus. The intention behind that unlawful activity was to frame Koberger. Do not tiptoe around this stance in court, because the judge has shown that they are not concerned about how the DNA was obtained. They're only concerned that the DNA was obtained. If Koberger's DNA is claimed to be discovered at the crime scene, Taylor needs to not focus on how the state and the FBI obtained that DNA, because you're going to struggle uphill. We're not saying she shouldn't challenge it, but she needs to take a step back and realize that the judge is clearly presenting a stiff resistance. We're not legal experts by a long shot, but this is a form of debating, and we're pretty good at that. So in a debate, this wall that has been put up by the state needs to be chiseled away at. Taylor is in fact chiseling, but ironically, focusing on the DNA is a small area on the wall. One area, which is the weak spot of the wall, exposes the truth from that night. And you all know what that would be. The wall would crack in the center and crumble. But let's continue.
Your Honor, for the purposes of the Fourth Amendment protections and Article 1, Section 17 of the Idaho Constitution, we are looking to see if somebody has a privacy interest that society is ready to support. In this case, if society is not ready to support suppression of every bit of our DNA when the government does not have a warrant and searches it, there is no privacy right left.
Do you have any cases that hold that?
I do not have any cases that hold that, nor do I have any to the contrary that say that's not the case. Your Honor, this is a situation where this identification was done in complete secret, behind closed doors, and it's been continued to be a secret. And that should raise red flags for Your Honor about privacy interests that are at stake. The court can see from the various affidavits in this case that there's a lot of things done that don't say how Mr. Koberger was identified. And the reason for that is because nobody wanted to talk about what happened here with the genetic genealogy. That search was done by making a profile in Othram Lab. That search did not lead anywhere. The FBI took over the search, and from there they did things that we have no idea what it is. That entire segment of this case is secret. We have been through several motions to compel to try to get information, and we've gotten very, very little information. The court should know that we learned today about policies and procedures of Othram that we have not been able to take a look at. Those have not been produced. In fact, we've been told they don't exist.
Okay, that's a nice attack from Taylor. Of course, Koberger was not in the CODIS database. And then the dreaded FBI took over and processed his DNA through IgG. But this is the same FBI that snooped around and collected Koberger's father's DNA in Pennsylvania. Yet Taylor needs to attack them as well. Do not be afraid to call the FBI out for their actions, because it is the FBI who took over the investigative work regarding the DNA. Essentially, they are the reason Koberger is facing okay, of course we know that.
We learned about investigative work that was done after Othram had done the work that they could do and before the FBI took over, that we learned about for the first time this week. Not the motion to compel process. This was a giant secret. When we get to the FBI, we don't know who did the work. You heard that any of that information is redacted. We don't know who did the work. It's a giant secret. We know that by the time the FBI gets involved, the profile, the text file, that's a snip to use to try to identify somebody is more than twice as big when it gets to the FBI from Othram. We don't know how. We don't have any notes. We don't know who did any of the work. We don't have any lab protocols. We don't have any quality assurances. It's not reliable.
You're not asserting that Mr. Koberger's DNA sample was uploaded into any of those databases, that his was, like, for example...
And there's the key, which prompted the judge to interject. As our saying goes, when there's mystery, there's secrecy. And when there's secrecy, there's conspiracy. The FBI carried out secretive investigative work because they were building a frame job against Koberger. We broke this down pretty early in our investigation because it was obvious, despite Koberger not being in CODIS. It doesn't justify the FBI keeping their investigation a secret regarding his DNA and how they matched it with the alleged DNA discovered on the knife sheath. If you ask me, they don't physically have any DNA on a knife sheath in the... Wait, just wait a minute. Just thought about something. What if the DNA on that knife sheath is one of the males who weren't identified at the scene of the crime? Blood was left on a stair rail, which indicates they were upstairs at one point, and a knife sheath was discovered in Madison's bedroom upstairs. Where's the fucking investigation here? A male's DNA was discovered on the stair rail, that being blood, which means he was upstairs at one point, where two victims were discovered stabbed. Hello. Who the hell is this guy, and why is he still walking around free in society? Is this from carrying bodies upstairs? Downstairs? Is this Hunter after discovering the victims deceased in the home? We don't know who the fuck this is, which proves this was a cover-up. Also, this wasn't reported early on regarding blood on a stair rail. We knew that there were 3 additional males' DNA at the crime scene, but there was no mention of blood left by those males. Trust me, we would have jumped all over that information. And the reason they never disclosed that key information early on is because there would be blood left by other individuals at the scene of the crime. Yet no blood was found whatsoever on Koberger, his vehicle, his apartment, nowhere. Again, another investigative violation by law enforcement, withholding that information, but at the same fucking time reporting other males' DNA was discovered. Cover fucking up. Perhaps the glove discovered in the yard, which also had blood on it, was taken off after the murders, and the trace of that male's DNA was discovered. A trace, of course, due to the blood of the victim covering the knife sheath. This is how a trace can be detected, as forensics examines the knife sheath, and the blood on the sheath exposes a trace of the male's DNA. Let's keep going.
His own DNA was one that was matched from the crime scene. Not asking whether the crime scene DNA was uploaded, but whether he had, as a, for example, customer of one of these companies, uploaded his DNA.
Well, Your Honor, I don't have the JED.com file. I don't have...
You're not asserting that fact, correct?
Your Honor, I'm not sure what the court is asking me.
Well, it goes to whether or not your client has standing to complain about the searches of the databases, because as the state has posited, that wasn't his DNA that was searched. At best, it was his ancestors.
Well, Your Honor, I am not sure why we're here if the state hasn't alleged that Brian Koberger's DNA was on the knife.
No, I'm not talking about the knife sheath DNA. I'm talking about what they tried to match it.
Your Honor, I would answer it this way. The way that those databases work is looking for shared DNA. Those databases don't turn out a name and say this is
I have a privacy interest against any of my relatives that might want to upload their DNA to one of those systems, I should be able to stop them from doing that because I share some DNA with them?
That is certainly not what I'm saying. What I am saying, Your Honor, is if somebody takes your DNA and uploads it, I think you have a privacy interest in your own DNA.
But not necessarily in, let's say my DNA is taken lawfully. What privacy interest do I have in the search of the DNA of others?
That's a loaded question.
Why is it a loaded question? Isn't it a factual question?
Well, it is, Judge, but you're assuming that the DNA was taken lawfully, and our position...
That part is an assumption. In my hypothetical, I said my DNA was taken lawfully. Why would I have standing to object to the search of other people's DNA simply because I might share some genetic information with them because they are distantly related to me?
Okay, this is where a bunch of semantics start overshadowing the core of Taylor's motion. Basically, the judge is saying Kohberger can't contest anything regarding privacy rights because he is charged with murder. It's that simple. Someone who is alleged to be a murderer, which a genealogy website was used to match his DNA to DNA at a crime scene. Well, the court could care less about the alleged murderer's privacy being violated because in their eyes, there isn't a violation. Everything was done within the law, aligned with their investigation.
Well, Your Honor, our position is that this work was not done lawfully, that it was unlawful, that there needed to be a warrant, that this was done outside of a warrant. And I'm not asserting on behalf of anybody else in this, any relative, anybody who might have been named or not named. This is about an identification process. It needed to be a lawful process. It wasn't a lawful process. It was in violation of Mr. Kohberger's rights. I don't know how he cannot...
How is it in violation of his rights?
Excuse me?
How was it in violation of his rights?
Well, Your Honor, he's been in custody
You're
for
saying
2
that,
years.
I understand your position, which frankly is not well supported in the law, that if, hypothetically here, he went to this crime scene, committed these murders, and left DNA on a piece of evidence, that he now has the ability to object to that evidence being searched for identification purposes. There's no case that suggests that, that concludes that. And it seems to me to be an extreme position to take in light of the case law, and I'm trying to understand how you get there.
You see, this is the problem Taylor will always face. It's a revolving door that she will constantly go through fighting the DNA. And think about how absurd it is. The prosecution doesn't actually have Kohberger's DNA on the knife sheath. They just placed him in the home. It's that crazy, but that simple. We know his DNA was never there because the other male's DNA was never investigated nor identified, which is just outrageous, considering there was blood left behind by one of those males. Keep in mind that blood of a male at the home is not, I repeat, is not breaking evidence in these hearings. The reason it's being talked about now, of course, because everyone was left in the dark about this evidence early in the investigation. Detectives omitted this from their reports regarding those 3 additional males early on, which means they had identified those males quickly due to it being a blood sample, knew it was a suspect, because that same fucking blood left on the stair rail was inside Madison's bedroom, and decided to cover it up. Oh, let me see, a male's blood was discovered on a stair rail that trails back to a victim's bedroom. Never mind them. Let's focus on this 5.3 octatrillion traces of another male. He's the killer. The same with the black coat Madison was wearing that night. Yes, everyone concluded the black coat detectives were snooping around with on Taylor Avenue was the same coat Madison was wearing. Take something out, which appeared to be a weapon, throw the coat back on the ground, and walk off. More evidence they swept under the rug, because they knew it would lead to a massive trail of criminals, who have to be protected by any means necessary for the town of Moscow's sake, you see? By that alone, we know Kohberger's DNA was never inside the home, if it was. Obviously, they literally went through the process of planting it there. And it would have been done in reverse, of course, as all the DNA they obtained from Kohberger was when he was already arrested. Not before, no, they didn't bring him in for questioning, then obtain a cheek swab from him. They did this after he was arrested, which was an unlawful arrest by law. The reason being, because if you arrest someone for a crime, then you need evidence that they committed the crime. It's that simple. You can't arrest someone before you have evidence they committed a crime. You can detain them for questioning, as reasonable and articulable suspicion may provoke such a detainment. They just started secretly investigating him, despite 3 other male DNA samples discovered at the home, including blood discovered on a stair rail. Now remember, one of the male's DNA was identified by November 20th, a week after the murders. That early hay? Well, what about the other 2 males? Apparently, it took detectives almost a full month to identify those, who were discovered physically inside the home. A man is tracked, suspected of either potentially being involved in those murders or being the murderer themselves. If they are suspected, then you bring them in for questioning. You don't follow them. You bring them in for questioning, asking them where were they on the night of November 12th, going into the 13th. They provide their claim. Further investigation may lead you back to this person. Why? Because during this time frame, the DNA being examined would result in what? Koberger family tree. Oh, but what if Koberger now decides to flee town? Well, it would end up the same way it ended up anyway, right? He was in Pullman and was arrested in Pennsylvania. The point here, everything about this investigation was unlawful. Taylor is doing a decent job on attacking that aspect, but it's the DNA that she has to expose as being manufactured into the crime scene. We can suggest that everyone is waiting for Taylor to just come out and say it. Make a firm claim that your client was framed with the DNA in the home. The prosecution blabbers out their challenge, and the trial will get here much faster.
Well, I think Your Honor is asking me about things that I anticipated the state would argue, their abandonment theory, and I would remind the court that the Ross case said that abandonment is a knowing, intentional leaving of something, for one thing. For the other thing, I think that the court is asking me to take a position where it feels like burden shifting to me.
No, I'm trying to understand the legal argument and how this is different from, example, from latent fingerprints.
Well, Your Honor, I think that things like latent fingerprints and like CODIS, there's statutes about CODIS in Idaho, about what's allowed in CODIS. This is a different search. This isn't an STR search. That's what happens in CODIS. This is a different search.
So I'm going now to, the constitutionality of using the DNA that was allegedly on the knife sheath. And because I understand your argument is twofold. One, your client complains that a search was done of databases of other people to determine whether or not any of them might be related to the person who left the DNA on the knife sheath. That's thing one. Thing two is an objection to the law enforcement searching the DNA by testing it and getting a profile from the knife sheath without a warrant. My question goes to that latter point, understanding the basis for that, because I can't find any case law that would support that idea, that somehow a warrant would be needed for DNA left at a crime scene.
Well, I think in our briefing, Your Honor, that we cited the court to some cases.
I think one concurring opinion in a case that held otherwise.
A brick wall here, better yet, a steel wall with this judge. But again, this is the challenge. Why would law enforcement need a warrant for DNA left at a crime scene? This is the question that will keep pulling Taylor down. And what it also does is creates a physical setting at the crime scene of that DNA being physically there, you see. This is why it will be difficult to dispute the DNA head-on.
Let's give a common example of planted evidence against an individual to show why we suggested that she focus her attention on the surveillance footage instead. A cop pulls someone over and claims they were speeding. Upon this stop, the driver refutes this claim, and there is a verbal altercation. The officer then tells the driver to step out of the vehicle, put their hands behind their back, and places them under arrest. Of course, the driver is frustrated and voices their concerns. The officer proceeds to search the vehicle, and then they place a bag of cocaine on the floor, comes out and tells the driver they found drugs in the back seat of their vehicle. Once again, the driver is outraged and tells the officer, "You planted that in my car." The officer puts the driver in the back of the cruiser, and they are hauled off to jail. The driver is charged with speeding, disorderly conduct, and possession of crack cocaine. They're processed in, stripped down, and thrown in a jail cell. Now we stop right here, regardless of what happens afterwards. What has just happened here? That's right, the officer planted drugs in the driver's vehicle to justify an arrest. It will be extremely difficult for the driver and their defense team to refute the evidence presented against them in court. How can you prove that the officer planted the drugs in the vehicle? The body cam doesn't indicate it was planted because of how the officer cunningly placed it inside while recording. So, how do you fight against what the officer claims they found in your vehicle? Well, unfortunately, there's no real effective way for the defense to challenge this evidence, because based on that very evidence the officer has, the judge can only go by what's being presented, not what is speculated to be true or not. The judge will continue to challenge Taylor about the IGG, constitutional rights, and such, because it doesn't change the alleged facts of the case, that the DNA of the defendant was discovered on a knife sheath. Sure, she can address the other males and their DNA, which one left blood on a stair rail. I mean, for fuck's sake, if that's not worth looking into a mistrial, then I don't know what is, But the judges in this case have shown, time and time again, they are not interested in dealing with anything else or anyone else, only who is in front of them, and that would be Koberger. Taylor needs to understand that her angle is not paving through. Let's continue.
Your Honor, I was going to talk to the court about third-party data, and I was going to talk to the court about the Davis case that talked about something that the police lawfully had and a subsequent test, the Skinner case, when there's something that's lawfully held, but there's a subsequent test. So those are the things that I want to talk about. Okay. Our first point is it was an illegal search, and this is if
search, which search?
Assumption.
Which search? It was illegal.
First the snip at Othram, then the snip at the FBI, and then the trash pool.
So you're talking about the DNA testing of the material left allegedly on the knife sheet.
I'm talking about the Idaho State Police Forensics Lab taking a piece of evidence given to them by Moscow Police Department, collected at the scene, developing a STR profile, uploading it into CODIS, and I think that's the King case that says that's fine. I know Idaho has statutes on CODIS, uploading it there and producing nothing. There are no results there. I'm talking about the next set of moves that are super secret that happen when there's a portion of the DNA taken and it's searched by Othram to create a snip. And then when that doesn't produce anything, the FBI says, okay, here we go. Let's search the snip ourselves. That's what I'm talking about.
Okay, so here's the complexity for both the prosecution and the defense. Othram's results came back no bueno, right? Now Taylor's argument is Koberger was not identified by the state lab initially. Then this sample was then handed over to the FBI, who then used IgG, which resulted in a family tree of Koberger, which technically doesn't prove it was his direct DNA at the crime scene. Fair point. But the problem here is that the family tree includes Brian Koberger, you see. Taylor can't refute that the genealogy results include Koberger. But the prosecution can't rely on those results entirely neither. So even though it's not a direct DNA match, it's a match by genealogy. The judge would have to determine if the DNA, based on genealogy, is substantial evidence to rule Koberger was physically at the crime scene and was the killer. Even in this setting, there isn't empirical evidence he was the killer. Now, if you add surveillance footage of his vehicle entering that neighborhood the night of the murders, then he's toast. We're just hypothesizing within this fuckery, as we have come to the conclusion there isn't any DNA of Koberger nor his family tree at the crime scene. All of this was collected during the FBI's covert tracking, leading up to his arrest. Then once he was arrested and charged, now they want to collect his direct DNA. Okay, yeah. Then you have 3 additional males at the home, with blood left behind, who we can suggest are 85 to 90% more likely to have been involved in the murders, or even the murderers. Talk about substantial evidence? Sheesh. Anywho, let's wrap it up.
Those are the problems. As far as asserting family...
Specific DNA tests of the sample that goes from legitimate to illegitimate?
Yes, Your Honor, I think the Davis case is on point. If the court's theory that this is a lawful piece of evidence taken from the crime scene, the sheath...
Not my theory. I'm just trying to understand your position in light of the case law and in light of the state's arguments. I'm trying to find where the gristle is in this.
I'm adopting the court's hypothesis for this purpose, that the knife sheath was taken. I'm adopting it only for that purpose, and I'm relying on the Davis case that says subsequent searches need a warrant.
And remind me, Davis was the cell phone?
No, Davis was not the cell phone. Davis was blood, a sample with blood. The cell phone case is
Give me
Carpenter.
the cite to that.
I'm sorry?
Can you give me the cite to the Davis case?
I can. Give me 2 seconds. 2 seconds and glasses.
While Taylor is citing another case, let's mention something briefly. The chaos doesn't follow in anyone's footsteps. The chaos doesn't copy or steal, mimic, or whatever that person claimed we do. We present our own ideas our radical style that some don't care for too much, which is fine. We present our own theories, perspectives, and conclusions. We do utilize information that's presented by others because it's a collective effort in this investigation. But no one can honestly say with a straight face that there is another channel that investigates like the chaos sector. We are in a category of our own, and that's just the facts. Again, stop thinking we're true crime investigators. The chaos has never declared that. It's not a title we uphold, but it's a community that we associate ourselves with. Just wanted to point that out.
I apologize. I wrote the name down, but not the site in my notes, but I know it's cited in our briefing. Another page. It is 690 F 3rd 226.
Okay. Go ahead.
All right, and so those are the three areas that we believe that there should have been a search warrant and there wasn't. There is an expectation of privacy in one's DNA that society is willing to recognize. And I think I talked to the court a little bit about the things that happened in this case that were super secret. I think we'd gotten to the point where we were talking, and this goes to recognizing an expectation of privacy when there's all of this secrecy surrounding it. We had gotten to the FBI where the SNP profile was twice as big as that from Othram, and then the FBI went into databases that violate the Department of Justice interim policy. You heard a lot about that Department of Justice interim policy, and that policy it's on page 6 of that particular exhibit that the court has. It says that they're not to go into databases that aren't allowed. And they did that. The court has it in another exhibit.
How's that a constitutional violation?
Your Honor, it goes to privacy.
Don't suppress for contractual violations or even statutory violations.
I'm not suggesting that we do that. I'm suggesting that that's information that's pertinent to this court in making a very important decision as to whether somebody's Fourth Amendment rights were violated, as well as Article 1, Section 17 of the Idaho Constitution. The purpose of offering that information is because there's a policy, so there's a recognized expectation of privacy in what's contained in a SNP. In a SNP at all, there has to be a warrant to search these types of things, and there wasn't. There would be no need to have any policy if nobody cared about this. The court heard about the different IgG databases that changed their rules in terms of use after a different case used IgG to solve it because people don't expect to have their DNA searched.
That was the point of my question about whether or not Mr. Koberger's DNA was in any of those databases. In other words, did he submit his DNA and said, I don't want law enforcement to look at it?
Your Honor, I don't think that that's the way the question should be looked at. I think the question should be looked at in the way that we always look at warrantless searches.
It's got to be a standing.
Okay, now it starts to heat up a bit. Mind you, we believe this angle is slow moving. That's our stance. It technically doesn't take Koberger away from the scene of the crime, and that was our point. But Taylor is asserting that the FBI used IgG to basically manufacture evidence against Koberger because Othram didn't come up with a match. It's an effective angle, but against a judge that is hardwired with so-called evidence in front of him, so to speak, he is compelled to keep resisting Taylor's stance. And that was our point. It puts the defense in a compromising position, due to whether or not an illegal action eliminates evidence discovered at the crime scene. Now, what Taylor is doing is tiptoeing around her stance. That stance would be Koberger's DNA was never discovered in the home. Based on the Othram results, the FBI used IgG, which resulted in a family tree named Koberger. Here's the problem, you have a family tree of Koberger. But how do you track anyone down with that family name? Oh, you link that person with the white vehicle spotted in surveillance. Again, it comes down to the surveillance, not the DNA. This is why we wanted to know the exact date that the FBI identified the Koberger family tree in relation to the search for a white Hyundai Elantra. Remember, the FBI told law enforcement to inspect Koberger's vehicle and his body. The traffic stop with his father was December 15th, if I'm not mistaken. Again, the FBI was already tracking Koberger during this time. Rewind back a few days, let's say around December 10th, Koberger's vehicle was submitted to Moscow PD. Let's rewind back a few more weeks. Let's say around November 29th, WSU campus police spotted Koberger's vehicle in the parking lot, then notified Moscow PD. Let's rewind back a few days to November 25th, where Moscow PD informed law enforcement to be on the lookout for a white Hyundai Elantra. Here's where we stop. The so-called FBI expert identified a 2011 to 2013 white Hyundai Elantra in surveillance, allegedly. We don't know the exact date of this identification, but what we do know is throughout this entire time frame, from November 25th to December 15th, and we might as well include December 30th, the day Koberger was arrested, there was another male's DNA collected from the home November 20th, yet no investigation. The other males were later identified a month later, December 16th. Taylor should drop the hammer and state, quote, "I find it quite frightening that you have 3 male DNA samples collected from the scene of the crime, including blood on a stair rail, blood on a glove outside the home, and yet these males were not investigated whatsoever. I request that this entire case being investigated again, because how can the state stand here with a straight face and rely on DNA that they themselves couldn't match with my client? Then the FBI hasn't provided any information on how they match my client's DNA to that in the home. Yet, there are 3 males out there who could potentially be the killers of those college students. I am sick of these hearings, going back and forth about technicalities and semantics. The prosecution has been running away from everything that I have requested. You can gabble down on me as you wish, but this has to stop right now. The next hearing I anticipate is for the prosecution to provide the court with surveillance footage from the neighbor's camera." Unquote. Yeah, that would heat things up so fast, as Taylor decides to take charge in this case, instead of being, quote, "gently bullied by the state."
Your Honor, we're here because the state has alleged that a single piece of evidence ties Mr. Koberger to this case. They've alleged that there's a knife sheath that has DNA that they allege matches Brian Koberger. He's now been incarcerated for 2 years, facing capital murder. I'm not sure, unless we're shifting the burden to me, what else I can say.
Well, you have the burden of showing that the items ought to be suppressed.
This is a warrantless search. There's no justification for this search.
Right. Assuming a warrant is required for this type of inquiry.
Well, Your Honor, we think it is. And we think it is based on case law, third-party doctrine case law, that's Carpenter. Thinking about cell phones, that's the Riley case. If you have a cell phone that gets taken at an arrest out of a car, a subsequent warrant to search the cell phone is required. So we think a warrant was required for these subsequent searches. And there was no warrant in this case. There's an expectation of privacy.
I struggle with, I struggle, to be frank, and where you're going to have to try to convince me, I guess, is I struggle with the idea that DNA left at a crime scene, that there's any expectation of privacy by someone who leaves DNA at a crime scene, that DNA can't be, as you say, searched without a warrant to establish identity.
Well, Your Honor, I don't think any of us can go out of our houses without leaving DNA all over the place.
Not go to a crime scene.
The question of how something gets somewhere, that's the subject of the trial. I think the Carpenter case is really instructive for the court here, and that case was about, third party with cell towers. And there was a concurring opinion in that case. I think that's instructive. We leave DNA everywhere. If you carry a cell phone and it uses the towers, there can be a trail of where you went.
Everywhere?
I'm sorry?
Don't we leave fingerprints everywhere?
We do leave fingerprints everywhere, but I would say, Your Honor, that things like your movements, cell towers, the contents of your cell phone, those are really personal things. That's how you carry out your business. That's how you drive your car to go to the doctor. Your cell phone's heading on those towers. DNA is even more personal than that. The tests are so different than they used to be now. It can pick up all kinds of information. It takes very little DNA. DNA lives on surfaces a lot longer than fingerprints live on surfaces. So without more, they're not much of an indication of anything.
Now this is a nice spot to attack the state. What type of DNA was left behind? It wasn't blood, obviously, like the other fucking males left behind after they murdered those housemates. Yeah, I said it because it's the reason they haven't been investigated. It wasn't saliva, it wasn't a fingerprint, it wasn't reported to be any form of bodily fluids, rather a single source of trace DNA. And trace DNA does not mean you were physically in a home where that DNA was collected. That's why it's called trace DNA. If the judge continues to put up the wall, then just counter with the scientific evidence that proves trace DNA does not mean Koberger was physically inside that home. What this does is forces the judge to be more optimistic about the totality of the case, because right now, he's a bit pessimistic and unwilling to budge. So the judge goes from rebuttals to everything Taylor states about the DNA, to taking time to ponder the various possibilities in relation to the DNA. Yep.
You know from the exhibit you have and from the testimony that you heard that the FBI went into 2 databases that they weren't permitted to search. So if the court wants to go clear to that extreme, and the court shouldn't, the court should look at the Fourth Amendment. The court should look at expectation of privacy. The court should look at the 3 places there was a warrant required and it wasn't given. But if the court wants to go all the way down to whether or not there was a database searched where the people consented to have their DNA searched, our case is different. The FBI went into 2 other databases and searched those. There was nothing else happening until that happened. And it's instructive, I think, and important for the court to think about how secretive this all was. We are months from trial, and we are learning things about how the government identified Brian today in open court when we've asked for those things. There's a reason why there's so much secrecy. That's because there's a violation of privacy rights. That's why there's so much secrecy. Your Honor, this is an extremely important motion, and the court is going to decide whether we do have any expectation of privacy left or not. The IGG evidence in this case should absolutely be suppressed.
I suspect the state's going to raise an issue that you may need to respond to, but I'll let you respond to that if they do raise that issue.
I'll be prepared, Your Honor. Thank you.
Okay, Taylor closed pretty well there. In conclusion, her focus on the violation of privacy translates to Koberger's DNA was used to frame him for the murders. We read between the lines, and I'm sure everyone in the courtroom came to the same conclusion. This goes back to the poster mentioning showing her hand. It's almost 3 years in. The prosecution already knows the defense's attack, because they're the opposing side with the frame. This is why we stated in our final episode, titled Prosecution in Peril, that they are sitting ducks, but Taylor has to pounce on them and not move timidly. The secrecy of the FBI's actions mean there is something to hide, of course. There shouldn't be anything to hide. Wait, let me flip it around. From the judge's perspective, in which he claims it's not a matter of violation of privacy if that person's DNA was discovered at the crime scene. Well, if there isn't a violation of privacy, or better yet not relevant, then why has the FBI concealed the IGG process then? If the defendant is guilty, and the defense wants the prosecution to show their work, yet they are being secretive about it, then they cheated. And in this context, cheating translates to Batman and even WSU Kim in Pullman, calling the FBI soon after the murders, the plot was to frame Koberger to protect the drug trafficking ring, who were responsible for the murders. Then the rest is history. You know how it all played out. Yes, I mentioned WSU Kim, because she stated she called the FBI later that day. Also, she had prior knowledge of Koberger, apparently, because she knew he taught in the classroom next to her sons. She claimed he was the mastermind. He had dirt on those housemates and all. This went in one ear and out the other, to most people, who deemed her a liar. But there are certain things she stated, such as that, which indicated Koberger was being targeted in Pullman. She mentioned how there were individuals at the home, and a quote, creeper as well. She stated that she called Moscow PD about a creeper, but this would be a vague description of a potential suspect, right? Meaning, that creeper was accompanied with a name, you see? The claim that Koberger had dirt on those housemates. Where is she getting this information from? Well, she seems like the parent, who eavesdrops on their children's conversations, you know. Gets all the spicy news within the college circle. So, of course, with drug trafficking, she knew that Koberger was aware of drug trafficking on those campuses. That's what she meant by he had dirt on those housemates. But the dirt was not something he intended on exposing. He just saw too much, you know. And when you see too much, criminals don't like that you are aware of what they try to keep discreet. And that type of person, being prying eyes, who sees things that criminals don't want them to see, could also be described as what? You guessed it, a creeper. A term the college students may have given to those who are not a part of the criminal network, you see. Oh yeah, that's him. He drives a white Hyundai Elantra and stays in Steptoe Village. He goes to WSU and is a teacher assistant. He's making my customers nervous. We gotta do something about him. Don't you find it ironic that soon after the murders, Koberger was kicked out of WSU? Because WSU was in on the frame as well, we went over this. The FBI, oh yes, the dreaded FBI, notified WSU to plot up all these little scenarios that justified his teacher assistant termination, which resulted in him being incapable of paying for his college degree. We reviewed the allegations against him at WSU, and it was all fabricated nonsense. They alleged he would follow female students around, but then it was later debunked. It was to align with the creeper narrative, you see. We concluded that stoners and dealers on campus didn't like his strict persona. You have a trafficking triangle, being Oregon, Washington, and Idaho. These 3 states are where Bonnie and Clyde stomped around, and since we all know they were charged for the death of a college student's overdose, then mysteriously those charges were dropped. It's obvious those college campuses were the main source of drug trafficking. The University of Idaho perhaps wasn't as major because it's a smaller university and not nationally acknowledged like Oregon and even Washington State. But that makes it that much more appealing for the pushers, because they assume those students would want to experiment with drugs that they were not as familiar with, such as fentanyl. But who oversees all of this? That's right, the FBI. Don't think this is too elaborate. This is normal for the FBI, covert operations, my friends. You wouldn't think something like that was being carried out at a university. And sure enough, WSU Kim stated both universities were a part of it. A part of what exactly? The drug trafficking? The murder cover-up? Or both? But I think she's a part of the frame with Batman. All of this will be exposed once that damn surveillance footage is released. We'll be right there to expose it as well. This is the chaos sector.